Marbury v. Madison is actually a crazy decision. Marbury v. Madison, 1803, it established judicial review. When you read Marbury v. Madison, it begins, well, does he have a right to be a justice of the peace? Well, the president signed it, the Senate appointed it, he had the thing delivered, or no, it was signed, sealed, but not delivered, right? He didn't get a commission. So it was appointed, the damn Secretary of State went ahead and affixed a seal to it, the Senate confirmed. I mean, this is like a lot of processes, but it was a bunch of midnight judges, and then it goes to the next administration, right? John Adams went ahead and appointed like 70-something judges the last hour of his presidency, which imposed upon Thomas Jefferson 70 new presidents or new judges, and it was like justice of the peace, so like small claims court in D.C. And Thomas Jefferson actually kind of split the difference. He had went ahead and accepted most of the 70 appointments except for 17. There were 17 of them that he would not accept the commission of. He's like, no, that asshole, I don't want that asshole doing small claims. He's not even good enough to be a small claims judge. And that asshole is Marbury. Madison is the Secretary of State. He's going to be the president later on. Let's read a little quip here. It is then the opinion of the court that by signing the commission of Mr. Marbury, the President of the United States appointed him a justice of peace for the county of Washington and the District of Columbia, and that the seal of the United States affixed thereto by the Secretary of State is conclusive testimony of the verity of the signature and of the completion of the appointment, and that the appointment conferred on him a legal right to the office for the space of 5 years. So we got 3 questions, right? Does he get the seat? Yes, Marbury gets the seat. Does he have a right to that seat? And if you have a right to that seat, do you deserve a remedy for the injury of not getting the seat? Yes. So he has a right to the seat. He has a right to address the wrong with a remedy. Now, the last question is the nature of the writ applied for, the power of this court. So does this court have the power to enforce a person who is wrongly stolen of a job? He has a right to right the wrongs, thus having this legal title to the office. He has a consequent right to the commission, a refusal to deliver, which is a plain violation of that right, for which the laws of his country afford him a remedy. It remains to be inquired whether he is, number 3, he is entitled to the remedy for which he applies. This depends on 1, the nature of the writ applied for, and number 2, the power of this court. Let's take a look at, how do you pronounce mandamus? It looks like a mandamus, and I am anglicizing it. I thought mandamus, Latin was a dead language, but apparently Latin is all over the damn place. Pronunciation. I want to get to how many times the Supreme Court has ordered the executive branch what to do. All right, here's how you pronounce mandamus.
Time. Then the court will be quite prepared to use the writs of mandamus, the constitutional writs.
He has a duty. He has a writ of mandamus issued against him by the court to fulfill.
Mandamus. I'm just, what it looks, mandamus. That's what it looks like. Well, it's not a mandamus. That's a mandamus. I mean, they've already pronounced it twice differently.
Fulfill that duty.
Legal proceedings like mandamus, they're fraught with legal complications. They cost a lot. In the year 2014, the government was obliged to
jurisdiction finding the statute unconstitutional. Therefore, Marbury can't get his writ of mandamus.
Correct.
Which is the remedy.
Okay.
U.S. Court of Appeals to issue a writ of mandamus.
So it seems like most of them are saying it's mandamus, but what is a mandamus? Mandamus is a court order. So has the Supreme Court ever ordered the executive to do stuff? Because Marbury v. Madison, while they said that James Madison had to answer for the, allegations, Madison doesn't answer, but there's 2 delegates that was sent in his stead, I believe. They worked for the thing. They had information to the thing or something. But ultimately, what happens is John Marshall is going to say that the mandamus, I'm going with mandamus, I like that, working class calls it mandamus, so a mandamus, according to John Marshall, James Madison does not have to respect the appointment of the previous administration because the Supreme Court cannot issue a mandamus against the executive branch. It's in contradiction to the Judiciary Act of 1789 or some shit. And then he's going to invalidate that Judiciary Act and call it unconstitutional. And so he says, no, we can't tell the executive what to do, but we can tell the legislative what to do if they break the damn Constitution. So judicial review is kind of weak in some respects because the goddamn president can do it as the fuck as he pleases and nobody says a damn word. But if the legislator, they pass a law, so they got all these people together and they all join together and they sign the damn thing, but then somebody says in the Supreme Court, no, that's no, you know how much fucking time and effort to pass a damn bill just for the fucking Supreme Court to say it's not constitutional? Meanwhile, the president can just rip up birthright citizenship and nobody is none the wiser. Is that how I want to end that sentence? So the question presented to you today, my fellow Americans, Supreme Court has ordered the executive to do stuff. Amy Coney Barrett and Ketanji Jackson both quoted Marbury v. Madison. There's a bunch to Marbury v. Madison. And I want to talk more about Marbury v. Madison, but this is my main point. The Supreme Court has ordered the executive branch to do stuff. The judicial branch has ordered the executive branch to do stuff. So they're trying to say this, permanent nationwide injunction, universal injunctions. You can't do universal injunctions anymore. If somebody flat out breaks your right to peacefully assemble, if I'm the damn president, I'm like, Americans don't have a right to peacefully assemble. That's my executive order. Permanent injunction would be a perfect remedy to undo that. That's a constitutional violation. On its face, it's a constitutional violation. Supreme Court has ordered the executive to do stuff. So whereas Marbury v. Madison ultimately did not allow Marbury to get his job because they couldn't do the writ of mandamus against the executive branch, the Supreme Court has ordered the executive branch to do stuff. For instance, in U.S. v. Nixon, 1974. Also in Kendall v. U.S. ex Real Stokes, 1838. Youngstown Sheet and Tube Company v. Sawyer, 1952. And Boumediene v. Bush, 2008, and Homeland Security Department versus the University of California, the Regents of the University of California in 2020. So that was against the Trump administration. So even though you have to do class action lawsuits now on behalf of the American citizens, I guess that's how you have to do it, right? Rule 23, you can't do a permanent injunction anymore, which fucking sucks. It fucking sucks. So when you get a Democrat president in there and he says, we're going to take the guns away from all Americans, the only way you can keep your guns is if you file a damn civil lawsuit to the federal court or you become part of a class action lawsuit in federal court. If you don't participate in the lawsuit in federal court and they take your fucking guns, well, you're just SOL. You just shit out of luck. You're just shit out of luck. The times that the executive branch has not answered the Supreme Court is a few times, right? You had that case, Georgia v. Worcester, with Andrew Jackson saying, all right, he issued, his damn thing, now let him enforce it. Almost John Marshall, Georgia v. Worcester. And then you also had the ex parte Merriman, is that what it was, with habeas corpus in Lincoln? You had the Gold Clause cases. You only have like 3 or 4 cases of when the executive branch said to hell with you, fuck all, when it comes to Supreme Court. Fuck all you motherfuckers. And so let's talk about the U.S. v. Nixon in 1974. The president must comply with a special prosecutor to turn over evidence. So this is going to lead to Nixon's downfall. But they were doing a criminal investigation. There was a break-in, Watergate Hotel, against the Democratic headquarters. And Nixon had some tapes that they said were relevant to whether or not he knew about it or if he ordered it or some sort of information. When it came to it, Supreme Court says you have to give up those tapes. And they're, very, U.S. v. Nixon is one of my favorite court cases, 1974, because they're saying that society has a right to every man's evidence. And they're saying that the point of the court is to do justice. And so we're not trying to get the president in trouble, but we are saying that if the president has evidence, then he needs to turn that evidence over so that way we can, go along with our little court case. We're doing a criminal investigation. In order to do a good criminal investigation, it's an adversarial, an adversarial system. So therefore, both sides need to get all the information that can be gotten. They need to get all the information that can be gotten. Nixon complied. He released the tapes with some of it missing, deleted, and then he's going to resign soon after that. That was a direct court order to the executive. No, Richard Milhouse Nixon, give us the goddamn tapes. He was like, hey, I'm the president. I got executive privilege. I don't have to give you the tapes. And they said, no, you're not privileged. We actually get to look and listen to the damn tapes. Kendall v. U.S. ex Real Stokes, 1838. Payments owed to contractors by the Postmaster General Amos Kendall under an act of Congress. Kendall said that the judiciary cannot issue a mandamus to a judicial officer or to an executive officer. You can't do that to me. I'm part of the executive branch, and you're just the judicial branch, which means you're nothing. You're nothing. Well, it actually turns out, yes, they can. For a ministerial duty required by the law versus a discretionary power, if you have to do the duty you're required by law, you're supposed to pay the damn contractors. The Postmaster General, Amos Kendall, under an act of Congress, you're supposed to pay the damn contractors. You didn't pay the contractors. And then you're going to say that the judiciary can't tell you what to do? I don't have to pay those contractors. Marbury v. Madison says that it's emphatically the duty and the province of the court to determine what the law is. That's the point. There's so much to Marbury v. Madison, just a lot of really good stuff. When it comes to, can you right the wrong? Yes, if you've been injured, then therefore there's a remedy. I want to know what Marshall would have said would have been the right order. You can't do a mandamus. You can't do a writ of mandamus against, Madison. What could you do? Is there something you could have done? Youngstown Sheet and Tube Company v. Sawyer, 1952. Truman issued an executive order to seize the steel mills to prevent a strike because he said that it would harm national security. This is during the Korean War. And the Supreme Court says, no, you can't do that. SCOTUS cried foul. No statute or constitutional power gave Truman the right to issue an executive order to seize the steel mills to prevent a strike, which he's a Democrat and he's going against strikers in the union. Youngstown Sheet and Tube Company v. Sawyer, 1952 is a Supreme Court ordering the executive branch to relinquish control of the steel mills. That's a direct judicial order. So we have several judicial orders. U.S. v. Nixon, Kendall v. U.S. ex Real Stokes, Youngstown Sheet and Tube Company v. Sawyer, and then Boumediene. Because of that, first name, I bet you nobody referenced Boumediene v. Bush, 2008, but that's detainees at Guantanamo Bay have a constitutional right to habeas corpus, and therefore the Military Commissions Act of 2006 was unconstitutional. And that's quite remarkable, to be honest with you, when it comes to the right of habeas corpus. You have, the damn Homeland Secretary saying, oh, I know what habeas corpus is. It's when the president has a right to kidnap you and throw you into a jail in South Sudan. That's what habeas corpus means to me. Does it mean something different to you? I got my truth and you got your truth, right? There was a lot of people that was mad about Lincoln for suspending habeas corpus, but then you got Stephen Miller straight up saying, yeah, we're looking into that. Yeah, we're trying to get rid of that goddamn pesky habeas corpus. What, you're saying that if you the government kidnaps somebody, they got to give you a reason? Why does the government have to give you a reason for why they just kidnapped somebody? Maybe they just fucking felt like doing it. What's it to you? Habeas corpus is one of our freedoms in the body of the Constitution as well. So when it comes to the incorporation doctrine, we're just talking about amendments 1 through 8, but you also have, freedom from the bills of attainder, freedom from ex post facto laws, the right to contract, and then the right to habeas corpus. That comes from the body of the Constitution. So our freedoms aren't just in the Bill of Rights. The Bill of Rights is a good list of freedoms because that's the great charter of our freedoms, the great charter of rights of mankind. Madison said something like that. That's the great rights of all mankind through all of history. So they're swinging for the fences with that Bill of Rights. Homeland Security Department versus the University of California Regents. This is the Trump administration. They cannot rescind DACA. It was arbitrary and capricious under the APA. The APA, which is like some fucking law. But DHS didn't provide a reason for attacking DACA. We want to attack DACA. Why is that? The law of the land is DACA. No, they're brown. They're brown, So I know they were born in this country and they're Americans, but actually, because they got brown skin, then they're Mexicans. I've heard people actually say that shit. All brown people are Mexicans, even if they're Guatemalan. That was actually in Clueless. I am not a Mexican. I am from Guatemala. So, that's some meat and potatoes there. I got some more meat and potatoes for you. When it comes to hypocrisy, this same goddamn Supreme Court, they didn't mind nationwide injunctions when it was against the Biden administration. But now that they're using nationwide injunctions against the Trump administration, now they got a fucking problem with it. It's like this Supreme Court is trying to turn these executive orders into actual law. Executive orders have the color of law. When it conflicts with the real law, then it's null and void. It's the color of law. Until you can get the legislative branch. In fact, there was one case, the major questions doctrine. So they had invalidated student forgiveness because of the major questions doctrine. If it's a major question, then it has to go through Congress, and Congress has to rule on the matter. Congress hasn't ruled on birthright citizenship. So according to the major questions doctrine, birthright citizenship is the law of the land. But the Supreme Court's doing the exact opposite. It's, when you think about how complicated it is to get Congress on board to all join together to pass a damn law, and then the president could just be like, everybody must love smelling my farts. They must say that my farts smell like roses. And then they must say, thank you, Mr. President, for farting in my face. Thank you very much. That's the law of the land. I just wrote it down on a piece of paper, and I just told you that's the law of the land. Lincoln, like with the Emancipation Proclamation, the most famous executive order in history, he thought about it, dwelled on it, took a year or two, fucking come up with it, wrote it, said in 6 months it's going to be the law of the land. So it went through this long process. Now the president is elected and he just comes in saying, all right, you got to smell my farts, you got to, love my, you got to suck this gangrene dick. You gotta lick all the dingleberries out of this fat guy's asshole. So Joe Biden had tried to forgive student loans, and those were stopped by nationwide injunctions. Fucking Mark T. Pittman, right? So that's one of the damn judges who stopped it. Fucking Mark T. Pittman. And then you also had two other judges here. Let's see, I circled him and put a little John A. Ross and John Randall Hall. So these are shitty federal judges. John Randall Hall is a prick. John A. Ross is a dipshit. And Mark T. Pittman is a goddamn douchebag. So when it comes to injunctions or declaratory judgments instead, Joe Biden tried to forgive student loans. They were stopped by nationwide injunctions. So the hypocrisy is disgusting. Biden v. Nebraska. This is a Supreme Court case, landmark 2023. We were using the HEROES Act. The Texas District Judge, Mark T. Pittman, issued a nationwide injunction which exceeded executive authority, right? A nationwide injunction. He was trying to stop the HEROES Act. You can't forgive, student loans. You went past your executive authority, Joe Biden. So a district judge in Texas issued a nationwide injunction. The Eighth Circuit upheld it. Then the SCOTUS did too, because they issued a 6-3 decision. The same fucking court. There's been no new members added or detracted from the Supreme Court for the past 2 years. So this is in direct contradiction of Biden v. Nebraska. The same fucking court. The same literal goddamn court. Roberts, Alito, Thomas, Gorsuch, Kavanaugh, and Barrett. The goddamn Trump called Gorsuch. He didn't call Gorsuch the right name. He don't even know who you are. Neil Gorsuch, he don't know who the fuck you are, because he's not trying to abide by the Constitution. He doesn't give a shit about the 3 branches of government. He doesn't work well with others. He's not trying to make sure the 3 branches are in cahoots. Biden then tried to do the SAVE plan, July 2023, higher education plan. This is another damn judge. Missouri federal judge issued a preliminary injunction, John A. Ross. That was at April 2024. Then August 9th, the 8th Circuit again. Looks like X expanded. Oh, yeah, to a nationwide injunction. So it started out as a preliminary injunction, and then the 8th Circuit said, no, it's not just going to be a preliminary injunction. We're going to turn this into a nationwide injunction. So you already got the HEROES Act being knocked down by the Supreme Court, 6-3, same 3 dissenters, Kagan, Jackson, and Sotomayor, and then the same 6, right, is conservatives versus liberals. And then SCOTUS did not lift the nationwide injunction, so therefore it stayed in place. The HEROES Act, right? So this is twice that a nationwide injunction made sure that college students didn't get their loans forgiven. It always bothers me that, you think you're so smart, college student, then why are you saddled with a whole bunch of fucking debt, Why are you saddling? How come you're not able to create a country where people could go to college? Don't you want an educated workforce? Don't you want a smart America? Do you want a bunch of dumbass motherfuckers everywhere? If you're so goddamn smart, then how come your fucking college education was so goddamn expensive? It wasn't worth it. If I had $100,000, no fucking way would I have spent it on fucking college. I would have bought a goddamn house and then bought a bunch of books and started educating myself. Violated major questions doctrine, which requires clear congressional approval for significant policy actions. That's what the Supreme Court had ruled in Biden v. Nebraska 2023. It violated major questions doctrine. The major questions doctrine says that for major questions, you have to have clear congressional approval for significant policy actions. So sorry, Joe Biden, the goddamn nationwide injunction is going to stick because fuck you. You're a Democrat. We're conservative ideologues, and we don't give a shit about you. We're going to go ahead and preserve this nationwide injunctions against Biden, but when it comes to our guy, we're going to say these nationwide injunctions are illegal. Trump v. Casa paves the road for them to destroy birthright citizenship, which destroys the Constitution. I like to think that Joe or Sally Ann American can be at home, open up their little pocket Constitution, and when they open up their pocket Constitution and they read one of their rights, they say, well, wait a second, what is this amendment number 4? What's amendment number 4? Well, I'm just, a regular average American. The right of the people to be secure in their persons, houses, paper, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause. So you can't just go around searching and seizing people's fucking shit. You got to have probable cause. You got to get a warrant. You got to get that warrant signed. So if a landlord wants to break into a tenant's house and fucking search their shit, if you just want to go to your neighbor's house and rummage through their shit. There is some big case about Rhode Island where the rebellion government, who was actually the better government, the old government had broke into the guy's house and rummaged through his shit. But that goes against the Fourth Amendment, right? The plain reading of the Fourth Amendment: no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So that means you got to be very particular with your warrant. You got to say, well, I think that damn Wyatt fucking Eggleston, I think that goddamn Paul fucking, what was his name? Some fucking dickhead, man. Fucking stole money from me. I gave him like $50. He was going to get me weed and he never came back. Yeah, I'll get you the weed. Yeah, here, give me the $50. I'll get the weed you want. No, I'll do it. So according to the Fourth Amendment, it's obvious. You can't go around searching and seizing people's shit if you don't have probable cause. And then you're going to get into the minutia of it. It says also you can't seize a person. The right of the people to be secure in their persons, houses, paper, and effects. So where it says you can't search and seize you can't search for, gold. I want to look for gold in the guy's house. You got to have a warrant to do that. But also, you can't just go around arresting people because it says people get to be secure in their persons. So that's where you get a lot of lawsuits that come out of the Fourth Amendment because of that person, clause. So let's carry on. Biden tried to do the HEROES Act. It got thumped. And then he tried to do the SAVE plan. It got fucking thumped. Supreme Court ruled in Biden v. Nebraska against Biden administration. They didn't lift the nationwide injunction when it came to the SAVE Act. The Eighth Circuit fucked them both, twice. It was the Eighth Circuit that fucked over the Biden administration. If you ask me what's more important, forgiving student loans or upholding birthright citizenship, forgive student loans. Do not rip up the Constitution. That's not even a question. One is good, one is bad. There is the additional forgiveness rule, September 4th, 2024. So now we're going to strengthen some of the other provisions of the, college law that says, okay, we already say that we could forgive student loans, so let's go ahead and just expand who student loans can be forgiven. Additional Forgiveness Rule 2024, September 4th, 2024. U.S. District Judge of Georgia, J. Randall Hall, issued a temporary restraining order. Oh, wow. There's a fucking nationwide injunction. Then the preliminary injunction issued by the Missouri judge, October 3rd, 2024, it blocked the rule nationwide. Well, why is that? A preliminary injunction is going to block the rule nationwide? So again and again and again, when it came to the Biden administration, the Supreme Court says it's okay to do these goddamn injunctions, whether it's a preliminary injunction, it's a temporary injunction, a permanent injunction, a universal injunction. You're just allowed to fucking injunct goddamn Democrats who's doing good shit. Man, if Biden would have actually got student loan forgiveness, then he could have actually, pointed to some accomplishment. What the fucking Biden infrastructure? So a bunch of fucking government types got a bunch of fucking money and then they didn't help anybody else out. They pocketed that shit. So the major questions doctrine, has birthright citizenship been talked about or decided about Congress? The answer is no. The only way you can get rid of birthright citizenship is with an amendment or with a constitutional convention. You got to either rewrite the whole Constitution or get an amendment, which, takes 2/3 Congress, 3/4 of the states. It's a very huge bar. I mean, we got 27 amendments, so it's not impossible, but the last amendment was in the 90s. We've never, in the 2000s, ever changed our fucking Constitution. America's Constitution is the oldest existing Constitution that's still being used today, but Massachusetts is even older. So West Virginia versus EPA, that also uses the major questions doctrine. When it comes to the executive order 14160, which 14,160, there's no clear congressional authorization. There's been no clear congressional authorization to say that the president can go ahead and rip birthright citizenship up. So I want to think that the Supreme Court is going to do right, but now I'm thinking it's the opposite. They went ahead and ruled against injunctions because they're going to rule against birthright citizenship in a month, which is a goddamn shame.